Greetings, everyone, and welcome to this webinar. I'm Professor Thaldar of the School of Law, University of KwaZulu-Natal. We have almost 200 people already on this webinar, and we are really very grateful for all the interest and the support. This webinar is all about data and the law. I think we can all agree that data is enormously valuable in the knowledge economy, and that cross-border data transfers are increasingly becoming the norm rather than the exception. But how should South African data providers ensure that data sharing is done on fair terms and that their reasonable interests are legally protected? The answer is by having a quality data transfer agreement, or DTA, in place. And this is what our research group set out to develop: a top quality DTA template tailor-made for South African providers to use. It is a template, meaning that it can be used as is, or users can change certain aspects to suit their own needs. We've provided an explanatory memorandum to guide users and explain what are our reasons behind every section, empowering you as the user to understand the thinking behind every section and to make an informed decision whether to retain or to change any clause. Importantly, this is an academic project and for everyone's benefit. Unlike the MTA that was gazetted in 2018, we do not seek to have our DTA template made mandatory. Instead, it is intended as a free but top quality service to the South African research community. We would like you to use it because you find it useful, not because you're forced to use it. I want to comment on the following. We've taken care to ensure that our DTA template facilitates compliance with the broad range of statutes that are relevant to data transfer, ranging from the National Health Act to the Intellectual Property Rights from Publicly Funded Transfer Act to PUPIA. We trust that this will make the DTA template a very valuable tool. Speaking about PUPIA, another exciting development is, in the data and research space, is the Code of Conduct for Research in terms of PUPIA that the Academy of Science of South Africa is currently developing. So how does our DTA template relate to the Code of Conduct? The answer is that each of these two documents in their own specific way is designed to assist the South African research community to be PUPIA compliant. The Code of Conduct intends to do this by, among others, explaining PUPIA's data protection provisions in the context of research. Our DTA template complements the Code of Conduct by providing an actual agreement template that can be used for data transfer that will assist the parties to be fully compliant with PUPIA. In other words, the Code of Conduct for Research in terms of PUPIA that ASAF is currently developing and our DTA template can be seen as two sides of the same PUPIA coin. Lastly, a few formalities. Please note that this webinar does not constitute legal advice. Also, I would like to acknowledge the financial support by the US National Institute of Mental Health and the US National Institutes of Health. The content of this webinar is solely the presenter's responsibility and does not necessarily represent the official views of our funder. Let me speak about our agenda for today. First, we will introduce our new data transfer agreement template. This will be followed by our online tool to find and compare specific aspects of data protection legislation in African countries. We will then conclude with a question and answer session. When we start with a question and answer session, we will activate the Q&A function on Zoom. So if you have questions, make a mental note, and then you can type the question to the panel during the question and answer session at the end. We look forward to answering lots of questions. So everyone, to introduce us to the new DTA template, I would like to hand the microphone to my colleague, Dr. Lee Swales.
Terrific. Thank you so much, Donrick. Welcome, everybody. As you've just heard, my name is Lee Swales. I am an attorney at Livingston Leandi, and I'm a research fellow at the University of KwaZulu-Natal. So my brief presentation is going to be to take us through the DTA, to look at some of its key parts and to really just get some background to it. So we'll start with a background and a context, just building on what you've just heard from there. Then look at the methodology, how we went about it, what we did, how we developed it. Speak briefly to how users should look to utilize this tool. And we'll analyze some of those key clauses, just to give you a sort of high-level overview of those clauses. As Prof. Taldo's just said there, we're going to have a Q&A session at the end. We've allocated quite a chunk of time to that. So to the extent there are any questions around implementing, around populating, just questions around anything to do with the DTA, make a note of them, and we will try as best as we can deal with those at the end of the session. So just some background and some context. I think, as we all know, on this webinar, data protection and privacy is playing an increasingly prominent role in society. We can go back to the late 1800s, and we've had academics and former Supreme Court justices in the United States writing about privacy. Fast forward into the 40s, 50s, and into the 90s, various instruments were promulgated around privacy. And really in the last decade or two, particularly with the implementation of the GDPR in Europe and POPI or Papaya in South Africa, the law started to really mature around data protection. And as I say, there plays an increasingly prominent role in what most of us do, and that's research, potentially, sharing data, whether it's for commercial or non-commercial purposes. So really, that's the sort of context. This DTA template, it's this isn't a novel idea. Various academics have been talking about this for some time. We do have an MTA, which is a material transfer agreement, which speaks to the transfer of specimens. But there has been talk of a DTA for some time. So our research group decided that we would take this project on. In light of really what's going on around us, you've seen we've had some engagement with our South African information regulator, and there's work going on in a variety of spaces. Unfortunately, yet we don't have a template that has been produced. What we do have, though, is ASAF is producing a code of conduct, which will, as Prof. Taldo said, assist many research institutions in complying with data protection legislation. We've got industry codes that are starting to develop in a variety of other industries as well. So we're seeing in a South African context specifically, and more broadly in an African context, guidance is starting to emerge. It's not yet, though, to sort of be hypercritical, as the guidance isn't as settled. Perhaps somewhere like the UK or parts of Europe, we've got the ICO, and there's a variety of notes that have been sort of published and standard contractual clauses that makes life easy for academics, for scientists, for users to transfer. So we really wanted to take a first stab at producing something that we feel is compliant legally and that will assist in transferring data, both within South Africa and beyond. So our DSI Africa Law Research Group comprises of law professionals and academics. And as I think we've got a variety of goals that my colleague Aliki will speak to the website just now. And if you want some more detail on that website, on our goals, you'll be able to see that on the website. But the one specific goal that I'm being involved with that speaks to what we're dealing with now is having a high quality agreement that can be open source, that can be freely available, with the sort of research community in mind. So that really was the background and what we're trying to do. So how did we go about that? Prof. Taldo and I had a group of postgraduate students who we were working with them last year and basically produced a lengthy report on data transfer agreements. We like to call it really like an anatomy of data transfer agreements, where we looked at a range of various data transfer agreements, around 30 of them as a starting point, just to understand what clauses are typically used, what mechanisms are, what's out there, what's available. And we went through that in detail. And from there, we started to sort of branch out and look at more broadly. I've fortunately got some experience working in the United Kingdom and London in a legal counsel capacity. So looked at some of the ICO and EU SECs and had a look at how it's achieved in other jurisdictions where the laws had a chance to perhaps mature a little bit further, where we can take some learnings from, and also look at it from a perspective of perhaps coming up with our own African solutions as well. So we looked at what was available in a South African and African context. And then as a practicing attorney, I also looked at what's going on in practice. How are other entities in commercial spaces, how are they dealing with this? How is data being transferred both locally and abroad? So that was the sort of mix, and we obviously put together what we feel is quite a strong team based across South Africa, and in the UK. And yeah, we had a variety of meetings, of discussions. We met with some of our consortium partners, with a variety of privacy law experts. We had an engagement with the South African Information Regulator. And all of that put together, we then produced a draft agreement, which we batted around for several months, trying to sort of refine it, and then produced a beta version of the agreement, which we published and tried to sort of make available as widely as we could, seeking comments on that, seeking some feedback. We got some great feedback, which helped us improve the agreement. And just maybe say this before the thought flies out of my head, and by no means, are we saying here that this is the final, product? It might well be that as time goes, there might be a second version that we can improve on. So of course, at any stage, we do welcome feedback on the agreement, but we've taken the beta version. We've effectively now published a version 1.0, which is freely available. And that comes together with an explanatory memorandum. So part of our thinking, part of our methodology was understanding that this is not solely tailored or created for a group of lawyers. We'd like this to be as user-friendly as possible, obviously within reason. I mean, as much as we do try to use plain language and try simplify things, there is a point at which we have to use a little bit of legal jargon and refer to some legislation. We try to do that as sparingly as possible. Maybe we can achieve that better on the next run, but that's what was the thinking. So in addition to the agreement, sitting together with it, we've got an explanatory memorandum. Now, basically what that seeks to do is just explain the rationale or justification for each clause. Why is the clause there? What does it do? For you as the user, or if you are assisting the user, what is it that might need to change about the clause? So for example, in intellectual property, we produce what we believe might be a standard position. But you might think, well, for our organization or our research group or our university, this is not how it normally works. So then you might want to tailor that particular clause. And there's various examples of that throughout the agreements and throughout the memorandum, where we do give some sort of explanation and some possible alternatives that you might consider in your use of the template. So yeah, that was how we put it together. How do you use the DTA? How do you go about using it? So obviously, as I've just explained, it comes with the explanatory member. So what I would say is, if you're new to this type of agreement, you might want to maybe start with the explanatory memo, have a read through it, understand what the clauses are there for and how it's there, maybe have that side by side with the agreement. And that might be a good starting point to go through the explanatory memorandum. Given that it is a template, there are times when you're going to need to insert certain information. So a good example is right at the start. You're going to need to insert the names of the parties. That's on the cover page. Then in, for example, clause 2, you're going to have to again insert the names of the parties. And there's a few other places in the agreement, like, for example, names of parties, addresses, and so forth, that you might need to insert. These are clearly, we think, clearly displayed, so it should be self-explanatory as to where you need to insert information. Another obvious one might be the start dates and perhaps the expiry dates of the agreement. What might work for one research team and university in one situation might not work the next time around. So there are, certain places where you're going to need to just apply your minds to what is it that we're trying to do, and how will that suit, how will we need to implement that in the particular agreement that we're using. We've also, with the view of understanding that most of you might actually be working with electronic documents. So what we've done is we've hyperlinked or linked the defined terms. So maybe an annoying feature to non-lawyers of agreements is this thing of defined terms, and sometimes it'll be in capital letters or a word with a capital, and that sometimes just interrupts the flow or stands out, makes it hard to read. So what we've tried to do is just keep it as natural as we can, but have those defined terms as hyperlinks or underlined. So for example, if we use the word project data, there's a definition. So we don't have to have a long 3-sentence explanation every time we use that to be clear on what we're referring to. We have it defined once in the definition clause, and then every time that word is, or that's those words, or in some cases a word is used, you can click the hyperlink and it'll take you back to the definition. So you might think, oh, what does effective date mean? What does parties mean? And you would click that and it would take you back. So that's something that we've inserted to try assist, sort of create a user-friendly type environment. So that the other thing to sort of belabor the point is that on a case-by-case basis, your use case will change between projects and obviously between universities. So what we've set out in the agreement is probably what we believe to be a standard position based on a load of other data agreements that we've seen and some experience of those of us in practice and in academia as well. That's not to say that it's cast in stone. And by all means, you need to change this as and when it will be required for your situation. Okay, so onto the more, let's say, analyzing the clauses and looking at how, what are the key issues that we are considering. So look, if I had put my lawyer hat on and take off my academic hat, and I was consulting with someone thinking about drafting a data sharing agreement or something similar, these are some of the key questions that you would be looking to answer. But on top of that, when you are looking at this template and you're looking to customize it for your use case, this is what you need to be thinking about. And some of it's obvious, but let's state the obvious. Who are the parties? Because you obviously need to populate that in the front page and clause 2. So give them some thought to what's the juristic entity? Is it a university? Have you who is it that's contracting? You need to, sometimes there's more to that than meets the eye. It might not be, for example, the School of Law is not maybe not the correct contracting party. So you might need to talk to your legal services or give that some thought around who's the contracting parties, who's involved in this contract. The next important point is, and it almost goes without saying as well, but what data are you transferring? Now, often in the agreements that I've seen, sometimes this is sort of given scant attention and the data is not sufficiently or with enough detail described. So this is something you need to carefully apply your mind to is, what is, this is the whole point of the agreement, really. What data are you transferring? So this, in clause 3, as in the definitions, as well as in Annexure A, there's a space for you to insert this. So this is something that you need to carefully consider around what's being transferred. The other thing that's quite important here is the project. What project does the data relate to? So in data processing parlance or language, there's a processing purpose, right? And so you want to give thought to what that is. Normally that's fairly straightforward for you to articulate or put in, but that needs to be done. One of the sins that we often see in legal practice around these agreements is the annex is not being populated properly. So try not make that mistake, is using the templates and then forgetting to put in the key stuff like the data, the projects, how long the agreement goes for, because then the agreement almost becomes useless. So give that some thoughts. Don't also just sort of rinse and repeat. So I did it in project X, therefore it must be the same in project Z and project A1 and so on. That's not going to be the case. On each new project, sit down with the project team, get a cup of coffee and give some thought to these key questions. The other real important question around any contract, but specifically one of this nature, is how long is this project for? When should the contract terminate? Sometimes you're going to have a very clear date. It needs to terminate on the 5th of December. Other times you're not going to know, because it might only terminate at the end of a specific project, which at this stage, when you're conceptualizing the agreement, may not be clear. So the agreement caters for that. And this is one of the clauses where you might change from project to project, and you will need to consider what is the term of the agreement and when might it terminate. So those are some of the key let's call them introductory points that you should be looking to cover when you're analyzing this. On to some of the legal clauses. This really gets into, some of them are standard and you won't change them in too many spaces. Of course, as we say, it's a template that you can change. But what I would say is, make yourself alive to, whether you're involved in a legal function or not, make yourself aware of and alive to what the privacy obligations are. Understand the duties, the obligations. Consider your team, consider your department. You might have an intern, you probably should have some kind of policy document, some kind of process. Just have an understanding on that, have a view on that. Make the team aware, get a training session together if necessary. So I would look at that particular clause. If necessary, pull your legal team in on it, and just have a view on what's required of you as a team in this process. The other side of this, when you're transferring data, is sometimes there might be a situation where the data is being monetized. Data is incredibly valuable. You might have heard that terrible cliche about data being the new oil, but it's become a cliche because probably it's true. And there's an inherent value in a lot of this data, specifically when it arises out of a variety of scientific studies. And that might, improve vaccine efficacy. It might improve a variety of other aspects relating to health law and beyond. So there needs to be a consideration of who owns this data. And your project, it might well be that that there needs to be some shared ownership model, or perhaps it's different. But generally, what we found is that the person, in simple terms, the person providing the data is typically going to be its owner. Now, why we feel this clause is quite important is because, in the past, we've seen that this ownership of data clause gets conflated or squashed into an intellectual property clause. And while that might sometimes work, not every case will be the same where it's adequately dealt with. So we've taken the deliberate decision to distinguish between ownership of data and intellectual property rights, aware of the fact that there may be some overlap. But what we've done is we've separated that out. And those are two very important areas. And without wanting to get too heavy on the on the legal jargon, but those are two areas that your university, your research group, your legal team, whoever it might be, or you as an individual in charge there, need to give some thought to. Who owns the data? How's that going to work going forward? Perhaps in terms of licenses and other things. In addition to, sort of tied to the ownership, and I've alluded to it, is the intellectual property rights. So that's creations of the mind, intangible ownership rights. Typically what we specify and what we see is there's this term called background IP or pre-existing IP. So if I come into a deal or into a transaction and I've already developed some great algorithm or some great idea or whatever it might be, it should as a default position be that I'm going to retain my ownership rights to that. And by using the IP I've developed to further some other project, I shouldn't lose the rights to that IP. So normally what we'd say is each party should own their own background intellectual property, but that anything new that you develop, and there may well be something new that you develop, perhaps something groundbreaking, and that might well be shared or probably should be shared or developed jointly. Now, there's some challenges to joint IP ownership, and sometimes disputes can arise around that in relation to what happens if we want to exit the project or we want to monetize, and so you need to give some thought to who you're working with and how best that might play out. But typically the basic position might be, if I've developed it and I come to the project, I own it. If we develop it together, we own it jointly. Now, that's not to say that's always going to be the right way to do it. It might sometimes be that you need to change that. So that's something to give thought to, and perhaps if necessary, take legal advice over. But those two, I would say, in addition to the data ownership clauses, are really some of the most important clauses that you will deal with in the agreement. There's other normal, what we would call boilerplate, because it appears in every agreement, clauses dealing with liability, dealing with breach, dealing with other things that you would expect to see in the legal agreements of this nature. But I don't think you need to worry too much about that, just knowing that it's covered, and that perhaps if there's you want to deviate from the standard, you might want to just discuss that internally with your legal function. The other thing that we tried to do, which doesn't appear on my slide here, but I feel worth mentioning, is in a dispute resolution mechanism, what we've provided for post-COVID, and we're all used to video conferencing and tools such as Zoom that we're on now, we've tried to create a dispute resolution method that will enable parties to resolve disputes across borders or across provinces via a mechanism such as we're using now. That's not to say you have to have that. You could change that too. And with agreements of this nature, we're hoping there isn't going to be disputes and that it's purely collaborative, but we obviously need to cater for that. So that was one aspect that I thought I should mention. The other one, I mean, as I say, there's many here that you could go through and dwell on, but the other one that might be a little different from what you probably have seen in the past, and this is one of the annexures that you need to make sure that's filled in and populated, is the benefit sharing between the parties. So you might well have a situation where between research institutions, you've got opportunities for staff, for students, maybe there's some funding in for a bursary. There might be other collaborative opportunities that arise out of or that are key to the transfer of data. So those would be articulated and put in Annexure D. And yeah, we would just hope that if there is anything insofar as that needed to be put there, that you would put it in. The same can be said for any of, as I say, just to dwell on this point, make a note or mental notes that when you're working through the template, make sure that you have inserted the information that's required and that you've populated the annexures. So yeah, that's the brief overview, and I'm expecting that there'll be quite a bit of, hopefully a few questions and things that we can give insight on, and we've got a chunk of time towards the end of our project, of our webinar, sorry, but I've brought a project. I've got the URL at the bottom there that you can click on to and have a look. Otherwise, I look forward to engaging with you shortly on questions and comments. Thanks.
Thank you, Dr. Swales. And I must also say from my side, the last one that you referred to, the dispute resolution, I think we really invested quite a significant amount of time to really flesh that out. And I think for our participants who have studied or who have read the DTA template, they would have seen that at the end, it makes use of the expedited rules of arbitration of AFSA, which I think is the leading arbitration organization in Southern Africa, and especially making use of their expedited rules can assist that if there's any dispute, it's really being resolved in a very authoritative, knowledgeable way, but very swiftly at minimum cost. One shouldn't think that just referring to arbitration in general is always a way to save cost. It can be even more costly than litigation. But if one plans your arbitration, if you plan your dispute resolution really in a wise way, for example, by using the expedited rules, defining it well, then dispute resolution can indeed be a relatively painless exercise. So, well, I would rather not start talking about the DTA. As you can see, I'm very enthusiastic about it. Dr. Swales, thank you very much. So it's now over to Ms. Aliki Edgecombe, who will be presenting our data protection legislation comparison tool that you will find on our website. Over to you.
Thank you so much, Professor Felder, and hello to everybody who is tuning in. I'm hoping that I'm going to add to the good news that Dr. Swales has already told us about simplifying your life. I'm going to even simplify it further for you. I'm part of the DSI Africa law group, and one of the great challenges that you have if you are involved somehow in trying to do health research across Africa is that you are having to wade through these kinds of documents. I hope that you can see them. You're wading through these kinds of documents, piles of them, hundreds of pages, or you're trying to look at very clunky PDF documents, trying to assess how data protection legislation is impacting your health research. I think by now you understand that it is, no matter what sector you're in. And I actually had a look at those who are joining us today. We don't just have scientists here. We have got, specialist librarians, people from all different sectors, but involved either in doing that transfer themselves or advising people. And so how do you go about doing that without losing your mind and all of the itsy bitsy-ness of what you currently have to deal with? So I'm going to take you through to our website and show you what we have available for you to use, and hopefully is going to make your life a whole lot easier. Right. So the first thing that you'll see is I've taken you to our website. Nice and easy. It's datalaw.africa. So you're able to go to that with ease, and you're going to see it obviously starts on a landing page. But what I'm particularly concerned with, and I'm going to take you through today, is how to actually look at the laws in an easy way. So I'm going to go to the law tab here, and I'll show you how absolutely divine this is. Firstly, you're no longer going to have to go through the entire internet looking at all the legislation that is scattered everywhere. If you've been involved in this, you know the frustration. Here it's all in one place. These are the countries in which we operate. So these are the ones that appear. But guess what? At a click of a button, there we go. We've got the Data Protection Act, the one that is currently the most up to date. I can go to another country. I want to know about Malawi. Guess what? Here we go. We have Malawi. Okay, so that's going to already, I think, make your lives a whole lot easier. No more painful hours trying to find the right legislation. Okay, but more than that, if you have had to do any kind of research where you are trying to do cross-border data sharing, or you've been tasked with finding out of how you are going to go do that legally. You're on the ethics committee, you're the librarian, you will know that currently what you have to do is go look at something like this, page through, have a look at all the legislation and decide, does this apply to me? Doesn't this apply to me? Then share it with another piece of legislation that looks completely different from another country. It's painful. It's very time consuming. It's easy to make mistakes. And so we have gone further to improve your life. And you will see that we've got a little button here. And this is our little search and compare tool. It appears at the top here as well. So if you go to our website and that's all you're interested in, which is fair enough, you can literally go straight there and it's going to take you to our tool. Now, this is a very nice basic tool for you to use. So it's very quick, easy, interactive, user-friendly. It's going to give you the targeted results that you're looking for. Nice and flexible, and what everybody wants to hear who's doing research, free. Okay, so the first thing, I'm just going to take you through what this tool actually looks like and what it can do for you. So just skip that if you get a little notice there. The first thing is it contains all our 12 countries, and you're going to see that we have put the various sections of different data protection legislation and pull that into different categories and criteria. So you're going to be able to search across up to the 12 countries that we have in one go, both definitions and provisions. And when you click between these, the criteria will change. So for instance, you're a researcher and you're trying to figure out, and I saw that some of you are from Kenya, so Paul from Kenya, we've got Asanda from South Africa. Okay, so here you are, you're trying to do research and you're trying to figure out, what do these various data protection legislation have to say in Kenya, in South Africa, in, let's just throw in Ghana, see if there's someone from Ghana here, or Botswana. We're going to click those because those are the countries we're interested in, right? And I want to know particularly about consent, because I know that that is a big one for us, wanting to know, how do we go about consenting our data participants or those who are involved in the project. Then all I need to do is click search, and ta-da, right before you, voila, you have got all of those compared. Where there isn't a particular definition given, it tells you that there's no definition given. It puts it one on top of each other so you can very quickly see the differences for that particular very important section at a click of a button. And you're going to see, just for further ease, you can actually click at the bottom here. So we base it on Sheets for ease of use. You already know how to use Sheets. So literally just click between the countries at the bottom if you want more information about them. We've hyperlinked all the acts. So you can literally go there and click that if you don't want to go back to our lovely fancy tool. So yeah, very nice and easy for you to do, and hopefully very easy. You can literally just click back to the report or just click report at the bottom, and there you have it. Well, to prove again how absolutely brilliant this is, you're going to click back and say now you're actually interested in a little bit more about consent. So now you're actually interested in what are the provisions of that? What do you have to go about doing in those countries? So click down here, and I'm going to go to consent of the data subject, right? I just want to look at that. I'm not going to go through the whole act now. You click search, and again, ta-da, right? Nice, easy for you to access. You've got everything one on top of the other. And the real brilliance of this tool is that it's completely easy. You're going to be able to download it. You can manipulate it the way you want to. If you need to populate it into a report for a supervisor or whatever, we've made it as easy for you to use as possible so that you can really get a good feel of what you have to do without having the old-fashioned way of trying to navigate these horrific documents all over the place. So I'm hoping that this is going to be something that you're going to play around with, that will be very helpful to you. You'll see at the bottom of our page, there's a way for you to communicate with us. So if you have any suggestions of things that you think, oh, that would be so wonderful if you could add that, well, we'll see if we can. So please send that through. This is 1.0. And so we hope that this will be as useful as possible for our research community. Something that is going to stream your lives and stream your research, that you're not being bogged down with trying to wade through everything. You're going to be able to quickly access what you need to. And if you need to read more about it, it's very easy then to access that particular piece of legislation. So hopefully that will be of great help to you. The final punt I'm going to do is, just because on the back of what Dr. Lee Swales was talking about in terms of particular areas you might be interested in, something like intellectual property, you'll see we've put together a resource page. You just literally go to resources and you go down, and you'll see that you can actually search through all of our documents. Here is intellectual property, and it is just going to pull up those that are most interesting, hopefully to you. According to year, you'll just be able to click and move along to that as well. So hopefully this will be something that makes your life absolutely far more streamlined, far easier to use and to navigate the law. But of course, I must just say, as a disclaimer, it's not constitution, it's not going to constitute legal advice. You will still have to go if you need something more particular. But this is such a fantastic starting point, and it's just going to cut a lot of the resources and time. And if time, we're talking money and energy that you were previously using, just trying to collate this information. It's now here for you. So, go and use it. Thank you very much for your time. And I hope that it is something wonderful and useful for you to use. Please don't hesitate to drop me a mail just using the bottom of our screen here. Nice and easy. All right, so that's it. And I'm going to go back to the rest of you.
Thank you so much. Thank you, Ms. Edgecombe. Participants, so these were our two presentations. It's now over to the Q&A session. If you've got any comments or questions, we would be very happy to attempt to answer them. And this part of our webinar will be moderated by my colleague, Dr. Dusty Donnelly. So over to you, Dr. Donnelly.
Thank you very much, Prof. Thelda, and very warm welcome to all of our guests. It's wonderful to have such a vibrant webinar. Questions are coming through thick and fast on the Q&A. Please keep them coming. I'm going to ask Ms. Edgecombe if she could field the first question. Thank you very much to Carleen Carl for putting such a fabulous and kind comment on there, that the African comparisons are incredible. I agree. And we're very happy that this tool has been developed. We hope it will be particularly useful for researchers in Africa. But the question for you, Aliki, both from Carleen and from Cornelia Malherbe, is will you be expanding the tool to include the GDPR and USA privacy legislation, as they are the most common with whom we as a research-intensive university work with?
Right, brilliant question. And I'm going to say yes, we will do that, especially if there's a need. And there, obviously, it has been expressed by a few of you. So if that is something that you would like to be included, we will certainly include that. The purpose of this is to make it as user-friendly and as useful as possible for you. So if you see that as being something that really can add great value, then that's something we'll definitely integrate into a version, the next version, and we'll do that as soon as we possibly can to make sure that that is available to you. So thank you for that question.
I think it's important that we started with Africa, and but I agree, if it can make it useful to the South African research community, then we can add those other countries as well.
Absolutely. So the next question is one that has to do with the content of the data transfer agreement. and specific reference to this very important issue of how to describe the type of data that will be included in the project data. I am going to read out the question and then refer it to Dr. Swales. The full question says, in a specific reference to describing the type of data in Annexure 3, Clause 3, what does the template include, or I presume envisage? For example, are there any quick drop-down options? Would I create my own research phrase bank from which to position and describe the data? I understand how different this can be from project to project and can access my own detailed info from the project charter and proposal, but I'm curious what options are within the template. Dr. Swales, do you want to tackle that one?
Yes, thanks. So with this particular template, sadly, we don't have a list of drop-down options. I think if that's what you're sort of envisaging, can I just select almost like a pre-populated sort of bank? Sadly, we don't have that available. Maybe in a version to come, that's something we could look at. But one thing there to consider is, given the variety and the depth of research projects available in the country and beyond, it might be difficult to sort of come up with let's say the right term. So I think the best thing there to do would be to speak with your research team and speak with your counterparts who the data is being transferred to, and just get a clear understanding. Use plain language, use your scientific terms, use language that's familiar to you. There's no point using a whole bunch of legal jargon that no one's going to understand. So my advice there would be to try use plain language and or terms that are familiar to your group. So just with as much, in simple terms, with as much detail and specificity as possible, describe the data. And then you would list that in Annexure A, and that would back cross-refer to Clause 3. I hope that helps.
Thanks very much, Dr. Swales. I'm sure it does. Now we have another question. In fact, it's two. It's a question and it's a comment, and they dovetail nicely together. The question is from Cornelia Malherbe, and I think I'll refer this to you, Prof. Thelda. She says, with regards to the DTA template, it is useful, we agree, thank you, Cornelia, especially for those institutions that have no research contract management team. However, I would be concerned if the idea is to have this DTA following the same route as the gazetted MTA from the Department of Health, as having a set in stone contract is always an issue from a practical and legal perspective. And Prof. Thelda did mention that that is not the intention, but I'm going to hand back to him to just clarify that. But Prof, what I think is relevant is a comment that came through straight after that from Julie Nadler-Visser, to say, just note that UCT and WITS have received confirmation from the Department of Health that the MTA template is not mandatory, but should be treated as a guideline. And I know that you yourself have published on this, so if you could perhaps add some comment, Prof.
Thank you. Yes, well, I don't think I should comment too much on the MTA. I think my opinion regarding that has been published. But regarding our DTA template, Ms. Malherbe, I completely agree. No agreement should ever be cast in stone, because then it becomes fossilized. It should be a living document, and the whole idea is we call the DTA template a template, with the idea that it can be used as is. It's ready to be used, but it's flexible. If you would like to change any aspect thereof, then that's up to the user to do, and that's also why we wrote the explanatory memo to try to explain what was the rationale behind each one of our clauses, so that you know why we put a specific clause in. Is this clause inserted to ensure legal compliance, or is this clause inserted for another purpose, perhaps, so that in your context, if you want to serve an alternative purpose, then you know you can change that one without compromising for example, on legal compliance, which is then served by other clauses. So we try to differentiate very clearly in the explanatory memo which of our clauses are serving, for example, legal compliance with the NHA or with PUPIA, and which of our clauses are simply a clause that we suggest this is a good standard formulation, or we suggest this is the best formulation, but we understand, we know that depending on your context, you might wish to change it to something different. So absolutely agreed. The whole idea is that this should be very flexible, and anybody is very welcome to adapt it to their needs.
Thank you very much, Prof. Thelda. So there's more questions and more comments coming through. Thank you very much for all of the positive comments. We really appreciate that and encourage you to keep communicating with us and sharing your experience of the agreement. The question that's come through from Michael Pepper is about data storage. Michael asks if there is reference to data storage, and if so, are there degrees of safety depending on the modality? So I think I should hand this back to Dr. Swales, if you want to take us to the provision in the agreement and perhaps speak briefly to the PUPIA requirements that would come into play here as well, Dr. Swales.
Thanks. So I think, broadly speaking, you would look at this to be the appropriate safeguards that you would take around that data together with the organizational measures. Now, you could, I think for a starting point, be aware that every organization, depending on its size and the type of data that's dealing with, may take slightly different steps. There's obviously a basic norm that we would expect to see, but one good starting point, and we've referred you to it in the template, is to look at some guidance prepared by regulators. The ICO is the regulator in the United Kingdom. We would have referred to a South African guidance note, but one just isn't available at the moment, so we've referred to the UK's one, and that's just around what steps you would take. So we haven't sought to give you sets of steps, because that would sort of presuppose your size and what data you were dealing with and various other things. We debated that long and hard, and we eventually took a view that, look, there's certain things that you need to do around having accurate records, around having policies, around having certain measures, both technical and organizational. And so in short, we haven't really put anything in there that you could just implement, other than to say you need to go and give some thought to what it is that you're transferring, what your organization is doing, and then put that in the annexure. If you put enough detail around, for example, the measures that you're taking technically, where you're storing it, how you're storing it, who's got access to it, and things like that, I think you should be okay. But if you've got no idea, as maybe this is the first time for some of you that you're dealing with something like this, I would say to you a good starting point would be to look at regulators' guidance, such as the ICO. And we've given you a link there, and the ICO, generally their language is pretty free of jargon, plain language. It kind of is easiest to read and follow. So that would be a good starting point if you want some ideas. Thanks.
Thanks, Dr. Swales. So there's a related question around data storage, or rather data itself, and that is whether there are considerations to the limits on the size or amount of data that can be shared in cases where international researchers request enormous data sizes. Is there a way in which limitations can be set? We find ourselves stuck in this regard. I note that this is mainly Africa focused, but what will be considerations continentally? So this sounds to me like more of a practical problem that African researchers are facing when they're collaborating with European institutions, just around the reasonableness of the amounts of data that are being requested, and possibly technical issues around how to transfer and safely transfer files of that size. So again, I think just to echo what Dr. Swales is saying, the data transfer agreement is a template, and it's not going to answer the individual practical problems that you might find on your particular project. It's going to provide a template where you can address how the parties agree to deal with those issues, but it can't provide a one-size-fits-all approach for each and every project, because each project will be different. So I don't know if you'd like to add anything to that. Let me just refer that back to the panelists for either of you to jump in there if you'd like to add something.
Yeah, thanks. I agree with what you said. There's just something else to think about is in one of the clauses there in clause 11 is obligations of the provider and the recipient. Now, we've given you a sort of general set of obligations seeking to ensure that you comply with relevant legislation and norms, but that's not to say that you could, for example, in your specific situation, maybe you put an obligation around size or around transfer rates or you could even introduce something new in the template in speaking to your particular team. So as we've sort of tried to stress, it's a template. You can definitely build on it. So I know there might be practical limitations that your institution might face, and then you might seek to engage with your counterparts and put some sort of limits or some sort of contractual limits on that. My best advice there would be to try ensure that you just discuss that with them and then try come to some agreement and then put that in the formal agreement if it's necessary. Thanks.
Thanks, Dr. Swales. Just to round off this point, and I think perhaps we've already addressed it, is a further comment on a similar issue from Carleen, that data transfer across countries is mostly conducted electronically. Are there concerns or recommendations around managing electronic transfers safely? So just to reiterate that really was answered by Dr. Swales in relation to Michael Pepper's question, that you should carefully set out what safeguards, technical safeguards, as well as organizational safeguards around who can access the data in Annexure C of the agreement. And he's referred you to some guidelines that exist internationally for recommendations, best practices to follow. So I think that we have dealt with that. There's also one more comment coming through to say from an attendee, we have confidentiality, non-disclosure and research conduct agreements that are signed before any data engagement or transfer. So thanks very much for that comment. I think it is important for us to understand, as Prof. Zelda alluded to at the beginning, that the data transfer agreement is complementary to whatever other agreements might be in place. And this is, in fact, a very complex exercise. And as you point out, there could be any number of prior agreements or engagements that determine how different institutions will work. So you might have to, speaking as a lawyer now, sort of my legal hat on, read our template very closely and make sure that it aligns with whatever agreements you already have in place. Where it doesn't, the template is customizable, and you must obviously ensure that it is adjusted to be consistent and in conformity with whatever your existing agreements or MOUs provide. So thanks very much for that comment. Another question coming through, which I'll refer to the panel. Is the DTA template only applicable to health data or all types of research data? There's a follow-up.
That's easy. I will answer that one.
Good.
It's all types of data.
Okay.
I can add that when we designed it, look, many entities in South Africa are transferring data both within South Africa and, of course, across borders. But and any commercial entity can also use this DTA, because if we can build our economy, then we are all very happy. So it's not only focus on academic institutions, but we must admit that when we designed this, we first and foremost had research institutions in mind. We're working in collaboration with other research institutions internationally. So in other words, not a typical commercial contract where you're simply selling data or licensing it out for commercial use. You can change the template to accommodate that, but typically we're thinking of a research institution in a collaborative project with another research institution abroad that will then be sharing the data in that context. That, for example, is why we're talking about benefit sharing and things like that, and joint IP ownership and so on, instead of the more commercial language that you would that would, for example, then be things such as a purchase and sale, or what would be the purchase price or the license fee, or something like that. But again, commercial institutions are very entities are very welcome to use the template and then just change those things. We've highlighted it in the explanatory memo. If I may quickly jump back to a previous question that related to non-disclosure at a certain stage, and then only the DTA when transfer is about to take place. Something that was pointed out to us after we published the beta version for public comment, and we really appreciated the comments received. And I remember one of our legal colleagues, Elizabeth de Stadler, then commented on this issue. Or it might be another one, so perhaps I shouldn't credit anybody for that now, but I just want to highlight our definition of project data, and that is in point 3.1.22. It's one of those definitions for the contract. So it reads, project data means the data transferred from the provider to the recipient as set out in Annexure A. And as Dr. Schwales highlighted, it's important to define that. But then the definition goes on, as well as any data actually transferred from the provider to the recipient as part of the project. So this is in order to cast our net, cast the net of the data that's covered by this DTA, to cast it broader. It might happen in practice that although people try to define the data at a certain stage during the negotiations, to define it quite well, it might then happen that during the course of the 3 years or 5 years or whatever of the collaboration, that that somebody who's part of the project then decides, well, this is perhaps also relevant data, and then sends it even though it's not originally envisioned or actually covered by the DTA. Those things might unfortunately happen in practice, and that's why we then expanded this definition to catch that data as well, so that if there's then any issue with that data, that this contract will then govern that issue as well. So I just thought I would quickly add that. Back to you, Dr. Donnelly.
Thank you very much. No, I think that was incredibly helpful, and it leads me back to two points that I just want to use to wrap up. And then there's one final question for you, Prof. Thalder. So someone earlier asked about the word transfer and how UKZN's Health Research Group understands the word transfer. Is there any concern that this implies a transfer of rights? And I know what my response would be, which would be no, because the agreement is absolutely clear that ownership will remain with the data provider unless agreed otherwise. And it's envisaged that it will be a licensing arrangement, a non-exclusive licensing arrangement for the use of the data for the purposes of the project described. But you also mentioned that it could be used outside of a research context, and there's a related question or comment on that by two anonymous attendees who want to ask if the template can be embedded into a repository to manage web-enabled access or downloads of data, and a further follow-up question saying, would I be correct in stating that the proposed template can be applied to data submitted to a public repository, accessible through a data access committee? Now, that's very interesting question, and I think it's one where my response would be that one would have to make some adjustments to the template to deal with the fact that the data is intended to be publicly accessible, but that you would be managing it through a data access committee. I think those things would
If I can quickly interrupt you there, yes, I think typically when people say it's publicly accessible, but it's managed by an access committee, then we should just differentiate that from data that is in the public, that's completely disseminated, for example, that you can just find on the internet or that's published in a newspaper. So it is then, although it's in principle, say, for example, it's a genomic database, and in principle, anybody can apply to get access to it, but it's controlled by a data access committee, then strictly speaking, it's not public. It's very much within a controlled environment. So sorry, I interrupted because I just wanted to clarify that point, because that's a fundamental way of how we as lawyers would perceive data.
I mean, if it's completely public, I don't envisage there would be a data transfer agreement, something like the Harvard project. It's available, access,
exactly,
to anyone on the internet. So I think that the question is concerning the latter category, where it is available to anyone to apply for access, but it comes through a data access committee. Would you like to comment on how that might work with the current template?
Well, I think in that case, the current template can of course be used. I think in fact with minimum changes, it will work perfectly in such a context.
Then there's just one final question which I've lost in the Q&A, but it related to dispute resolution clauses. So it was just a suggestion for the dispute resolution clause that there should be a subclause indicating that each party pay its own costs.
Well, I would like you and Dr. Schwels also to comment on this, but I must respectfully disagree with that suggestion. But of course, in your own institution, you're very welcome to change that and insert that clause. But I would rather suggest, I think our approach was, let's work out a good process where where the process lends itself to be as affordable and as swift as possible. For example, making use of the expedited rules for arbitration by AFSA. But to try to manage your financial risk in such a dispute by providing that each party will be responsible for their own costs will not necessarily always lead to a fair outcome. So, for example, if one party is clearly in the wrong and, for example, is grossly negligent with the data or intentionally contravenes the terms of the agreement, and it ends up then in arbitration or in litigation, whatever you choose, time and time again, but then contractually you're bound, you can never ask for a cost order against that party, even if the other party is clearly in the wrong and grossly negligent or whatever the case may be. So yes, I would rather leave it at the discretion of the presiding officer, say the arbitrator, in the context of AFSA arbitration, to decide on costs based on the facts before the arbitrator. And if the facts are such that it was, for example, more of a amicable dispute, that they just needed to have a declarator of rights, for example, then the arbitrator can decide that no costs will be awarded. But in the other scenario, as I've now mentioned, then I think fairness would dictate that costs should also be awarded by the arbitrator. But again, it's a template, so you're very welcome, if that is your opinion, then to insert such a clause if you think it will work better for your institution. I don't know if Dr. Swales would also like to add something there.
No, I agree with that. Not much to add. Just typically in legal proceedings, the costs follow the victor. In arbitration, you know, as Prof. Tolda was saying, it might not always be that way, but we would wish to leave it to the discretion of the arbitrator. And of course, as we said, it's up to you as a user of the tool to change it as you see fit. But I'd be very careful with inserting something like that. I would rather not. From a legal perspective, I'd avoid that.
Thank you so much. So that is a wrap on the Q&A that have come in so far. Of course, if you have other questions, please pop them into the Q&A. We do still have a little bit of time left. Lots of comments coming through for the work on the website and the fact that it provides such an easy to use tool, and that it focuses on Africa, which is a jurisdiction that has often been ignored. Since we have a little bit of time left, Dr. Swales, I'm going to pop you on the spot and just say that right at the outset of your presentation, when you were telling us about the extensive work you and your team of researchers did scoping different agreements, you also mentioned a technical term that popped up in your slide under the GDPR discussion, SCC, which was a reference to standard contractual clauses. So I don't know if perhaps just by way of background, since many of our attendees today do a lot of work with collaborators in the UK and Europe, could you just explain, with your background of working over there, what are standard contractual clauses and what is the approach the EU is taking to data transfer?
Perfect. So I think just broadly speaking, that acronym, I hope I didn't use it unknowingly, SCCs, as Dr. Only says, standard contractual clauses. When transferring data, in simple terms, one way to be compliant is to transfer it using agreements or clauses that have been effectively approved by a regulator. And so you've got a transfer of data from A through to B, using a particular mechanism that's been approved. Typically, you would see if you're transferring data cross borders, you might well see that some jurisdictions have data protection laws that are regarded as being compliant. Our South African regulator hasn't quite got around to performing an analysis around other various jurisdictions, and we effectively at this point are waiting for our own set of SCCs or standard contractual clauses. So by no means do I want to say that our tool or our template is an SCC, but it's going in that direction. It's, I guess, throwing a ball in that park to say that this is something that you can use to try and transfer your data. Yeah, I hope that answered the question.
I think it does. And I mean, if I can keep you online, or perhaps bring in Prof. Thalda and Ms. Edgecombe again, because of course, Ms. Edgecombe's PhD research looks at how we can make sense of all of the different data protection laws in different African jurisdictions, where, as she mentioned, that can be a gargantuan task of wading through different definitions, different statutes that are drafted in different ways. One concept we've talked about as a research group is the need for data corridors, and the idea that if we can make it easier to transfer data, we can really unlock the power of using data in health research. Any thoughts on whether we have perhaps, when you say set the ball rolling, is this the first step towards perhaps seeing greater collaboration between African researchers on making it easier to share data. Any thoughts, panelists?
Well, I can talk on this topic for hours. It's very exciting.
No, not hours, please, Prof.
I think that the purpose of this is not the forum. If people are interested, I think the whole idea of an African data corridor was first presented by our colleague, Dr. Beverly Townsend. She published an article on this, and I think it's available on our website as well. So that is very much something that we want to promote. And I can also say that this data transfer agreement for South Africa, this template, will also now form the basis for our research group to work on similar data transfer templates that's been customized for other African countries. So we will hopefully build up this repository of really excellent data transfer agreements that all align very well in various African countries that are aligned with those African countries' own legislation and their own, well, specifically their own data protection legislation, their health legislation, because that's also often very relevant, and so on. I don't know if any of our colleagues would like to add to that.
Just one thing to say there is that one would hope in the months to come is that there would be adequacy decisions in relation to South Africa, because with the Protection of Personal Information Act, we certainly, in my view, are on a par with many parts of the EU, United States, and it would certainly unlock a little bit more collaboration, I think, if there was just a wider view that we dealt with data appropriately, which I think we do. So yeah, hopefully that's to come.
Yeah, I think that would be very important, because then by complying with POPIA, we would also be able to reassure EU funders that we're compliant with GDPR. But there's a lawyer in the room, I think, because the questions come through in the Q&A in a lawyerly fashion, again asking about this term transfer and exactly what we mean by transferring data. So I'll throw this open to the panel. Given that this is a data transfer agreement, does this agreement cover instances where data is not transferred, but perhaps accessed through, for example, a cluster? So I'm assuming perhaps the data remains on a server, but access is given to collaborators who may be in other jurisdictions.
This isn't, well, it's I think it's quite a wicked problem, and our research group is in fact giving priority attention to investigating this and applying it to applying it to some of the methods used in the research community to share data, such as federated analysis and thus forth. So I will just give you my initial thoughts regarding this, and then I think I would appreciate if my colleagues can also jump in. But I think what's relevant because transfer is not defined in POPIA, so it's not really up to us to define it, but we can investigate what is a reasonable interpretation in the context of POPIA and given what the purpose of POPIA is. Okay, so if that is our approach, then the question is, even if you keep your data physically, say on a server in country X, but through your mechanism, you give, let's call it, access to somebody who's in country Y or in country Z, is the outcome any different from you simply transferring the data to that person? So if the answer is that the outcome is basically the same, then I would suggest that the answer to your question of what is meant by transfer would then include such a mechanism where somebody abroad is effectively given, is effectively placed in the same position as what the person would be through a physical transfer of data. Therefore, in that context of giving access to data, such as what often referred to as federated analysis, our suggestion would be to treat it as a transfer in terms of PUPIA, and then this data transfer agreement template would provide a very good way to facilitate it, to cater for it. But there's a caveat. We are still busy with our research on interpreting transfer. So this is my initial opinion, because I'm not afraid to share our ideas and the direction in which we're thinking. But once we have finalized our research, we'll most certainly publish it, and it will also be on our website. I can add that in some countries, at least in Kenya, there's specifically in their legislation a note that transfer would include giving access across borders. So yeah, so watch the spot. The web address, I think somebody asked there for the web address. It is datalaw.africa is the web address. But I think Dr. Swales and Dr. Donnelly may wish to add to my answer. I just saw that Dr. Swales put on his video indicating that he would like to add.
Yeah, so just to say that this is something that we realize is a little unclear in terms of the lack of a definition for the word transfer, but the sort of preliminary view that I think Dr. Thad has expressed, I would definitely go along with, and that is if you make available to another party, in other words, you give them access to your server, you're giving them a username and a password and a basis to access that data, and effectively that is the same net outcome. So I would favor the approach that PUPIA or GDPR or whatever it was does apply. Yeah, that's like the current view, but obviously subject to further investigation, but it looks like that's where we're landing.
Thanks very much. Yeah, I think it's a very important question. You've mentioned Kenya, and I mean, that's one of the countries where, although we can say data protection law is often broadly similar across jurisdictions, it's the devil is in the detail. And
it is.
You know, in Kenya, for example, as you're well aware, Prof, there's a provision requiring the consent of the individual data subject to transfer sensitive health data outside of Kenya, and that it then becomes a real issue. So in that context, as I understand it, there might be some models of federated learning where access to the data itself is not given to the collaborators. They can simply work on a system but never have access to the data itself. And so that might be also a privacy model to consider.
Yes.
That would then actually be intended to bypass this altogether by saying that there is no access and there is no transfer of data. Because of course, health data, particularly genetic data, might be very difficult, if not in some cases impossible, to anonymize. And that makes it very, very important to comply with the requirements for cross-border data sharing. There are no more further questions in the chat, so I think it might be a good opportunity for us to wrap up and remind everybody again of the, oh, sorry, I apologize. Someone saying they've got load shedding, and someone saying Dr. Swales gave another link. Please could he share that again as well? I'll make sure that he does. That's from Minri Khrief. We'll get back to you if Dr. Swales can't pop that into the Q&A now. And then there is actually a final question coming in as I picked up the buzzer to say we're wrapping up. From Anonymous, read the transfer question, is copying an encrypted data set with, and I'm laughing because it's another thorny question on which we've had many debates within our team. Is copying an encrypted data set without providing the key for decryption a transfer? For example, if party A wants to keep a backup in another location. Any final thoughts on that, Dr. Swales or Prof. Felder?
Shall I go first? Or do you? I would suggest that it's still a transfer, because whether you can access the data is not a requirement for transfer. But Dr. Swales, what do you think? If you can't access it.
The first thing to say is that the link, thanks for that, the link I was referring to was it's in the template. It's the ICO's website, ico.org.uk. It's in the template in Annexure C. So if you scroll to Annexure C on page 16 of the explanatory memo, sorry, maybe I should make that clear. It's in the explanatory memo. It's not in the actual template. So if you've got the explanatory memo open, it's Annexure C, page 16 across to page 17, and you'll see the link there. So that's where the link is. I guess this other thorny question, which we've gone back and forwards like that new sport paddle on, is how do we transfer? How do we define transfer? And if you don't have the encryption key, are you actually transferring it? I'm not sure. I guess at this stage we're leaning towards saying yes, it is a transfer. Sorry,
just remember,
I want to sit on the fence there if I could.
it might be that you can that you will receive the transfer key at some stage, or that you can conceive of another way to access the data. But I just think that having the ability to actually access or process the data in some way is not a requirement for transfer. So I don't think encrypting the data would then mean that you don't need to have a data transfer agreement. I would rather use the data transfer agreement template, even if you're transferring or making accessible encrypted data.
Yeah, I think caution is the word that's called for when you're dealing with data, particularly when that data contains instances of sensitive personal information, or what Papia calls special personal information, so health data, for example. But perhaps just to add, it seems like the question was related to transferring a copy of the data for a backup. And that might really be something completely different to what our data transfer agreement is intended to deal with. We're primarily focused on transferring the data for research collaborations. If what you're doing is creating a backup copy or any other back-end services of a technical nature, Papia would deal with that, in my view, as you're the responsible party for the data. You remain responsible for it, whatever happens to it throughout its lifetime. But if you're employing a service provider to store a backup copy, there needs to be, in any event, a written agreement between you and that operator, determining the way in which the data will be safeguarded and how they will deal with it, and the fact that they will not give access to it to anyone else except on your explicit instructions. So it might actually be a different kind of agreement that could be appropriate. I think you need to think carefully about what the purpose is of the transfer. This is a transfer of data where one's intending to use the data for research, not purely to store it or for some other technical back-end service. So that would be my 2 cents worth on that topic as well.
Yeah. And again, you can always change the template to make provision for something like that. But the template has, as we've said, primarily been designed for research institutions that are collaborating, that are working together, and where we know that the recipient will actually be processing the data for the project that they've defined in the template. There was another question earlier about the ownership of data and how that would be determined. So that's a bit of a complicated question, but on our website, you will find a reference to an article that our group has published. It's the multidimensional nature of human genomic sequence data, but very much the same principles would apply to any data in any event. So look out for that article on the website, the multidimensional nature. That will explain the issue of ownership of data, I think, in sufficient detail. There's also a link to a video, to a nice animated video where I explain some of those principles I tried to explain it in 10 minutes, which was quite a challenge, but you can also watch that, and hopefully that will then illuminate some of the aspects regarding ownership. So Dr. Donnelly, thank you very much for moderating this Q&A session. And colleagues, Dr. Donnelly, Dr. Swales, Ms. Edgecombe, thank you very much for being part of the panel in this webinar. And participants, everyone, your interest and your support are very much appreciated. And I hope that you can really make good use of this DTA template for the South African research community. Thank you, and I hope that you've got a good day further. Bye-bye.